Hello, everyone. Attorney Lee Marvin here, attorney in immigration and criminal law. Today, I want to provide some updates relating to immigration law. There have been a lot of changes over the last several weeks. I have 4 updates I want to provide. 2 are good, 2 are not so good. The first, on September 29th, a California federal court blocked the implementation of the new fee schedule the U.S. Citizenship and Immigration Services was putting in effect as of today, which was October 2nd. The federal court blocked these new fees from being implemented, so people will be required to pay the old fees until this can be litigated in federal court. The second update, on September 28th, a Minnesota federal court reversed the last decision relating to TPS. The last decision basically said that people with TPS could not use that status in order to fix certain deficiencies in their process in order to make it easier for them to move forward with the green card process. That has been reversed. So now people who have TPS status will be able to use that status to help them fix their entry issues of entering into the United States. This is a very, 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 very big deal for TPS holders. This is basically a game changer for those individuals who now will be able to change their processes here in the United States instead of having to leave the country and potentially be banned from returning for 10 years. The next update is relating to public charge rules. This has been a big deal since February when the public charge rules were changed. As of right now, the latest was a back and forth whether they were going to be used, whether they're blocked, vice versa. So as of September 11th, federal court in New York actually removed the block to that rule, and now the government is allowed to implement that new public charge rule against all applicants for permanent residency. So the public charge rules are back on for everyone. So there's no blocking of anyone. Everyone has to follow those rules. So the question now becomes, what if you already filed for your residency after February 24th, when the rule was first supposed to be started? What do? Well, between February 24th and October 13th, the government says you still have to follow those rules, but what they're going to do is send a request for evidence, basically telling you to provide that information now. If you file after October 13th, they'll basically reject your filing, and you will have to refile with all that new information. So it applies to everyone who's filing after February 24th. It's just whether you are going to be rejected or whether you have to supplement the information after you've already filed, okay? So a new proposal that was actually released today, October 2nd, is similar to the public charge rule, or actually it's accompanying that rule, and it applies to the sponsors. So the financial sponsors of these immigrants trying to get their green cards. This proposal is now going to require those individuals to provide basically proof that they are financially stable and they're able to support the immigrant. So they're going to have to provide credit reports, credit scores, certified copies of tax records going back 3 years. Instead of just providing the records, they have to be certified, as well as bank information to show that they have sufficient resources to support the immigrant if that is needed. Again, this is just a proposal. It will be challenged just like everything these days. But the public comment period is open, and it will be open for approximately 30 days. So keep your eye on that. Follow us because we have updates all the time. YouTube, Instagram, Facebook, we do updates. You can call our office at 616-450-2981 if you have additional questions or you want to schedule some kind of appointment to discuss your immigration matter. Thank you to everyone. Have a very nice weekend.